Welcome to Defending the Windy City with attorney David Drwencke. David is the founding partner of DRD Law, where he focuses exclusively on criminal defense in Cook County and beyond. With firsthand insight from his years as a judicial law clerk and a commanding presence in the courtroom, David brings a relentless commitment to truth, fairness, and precision in every single case. It's good to be with you. I'm John Lieberman, and today we are discussing police investigations, what's supposed to happen, what often doesn't happen, and how defense attorneys like David catch investigative shortcuts that can put innocent people behind bars. This is episode 16, Beyond the Badge, exposing flaws in police investigations. And it's good to see you, David.
Hey, thanks for having me, John. I'm pumped to be back. This is a great topic to be talking about.
Absolutely. So let's start with the basics, David. In an ideal world, what should a thorough and unbiased police investigation actually look like?
Absolutely. Well, every case will start with an allegation from someone. It's a victim. It's someone who sees something, perhaps an eyewitness, and the police are involved at that point. They've been called in. It's 911. A police report has been made, and now the ball is officially in the court of the police or detectives to conduct an investigation into who did it. Whatever the allegation may be. And if there's an allegation that actually specifically names someone, is that really the person who did it? And in a perfect world, no stone is left unturned, that there's an assumption and a knowledge that, of course, people hopefully are not lying, but we acknowledge that they do. And that theory is explored, that somebody's come and made an allegation from a low level, somebody pushed me, punched me when they weren't supposed to this is the person who shot someone else or sexually assaulted someone else, where it can't get any more serious. Well, part of that investigation should be trying to show whether or not that person had a reason to lie. Should we believe this witness? Should we believe this alleged victim? And the reality is that's not always what happens. But in a complete investigation, all theories are explored, all evidence is attempted to be uncovered, and that when an ultimate conclusion about whether to proceed with charges or not, or to turn it over to the state's attorney with an understanding, yes, we believe this is our suspect, this is the person who did it, it's because that's where the evidence led them, as opposed to what we'll talk about later in this episode, which is just following what they want to follow, believing an alleged victim, and not doing that, uncovering every stone. That's following up with the ability and the understanding that people may lie. That's where we ultimately catch a lot of issues, investigations.
So, David, you alluded to it, but kind of what are some of the most common investigative flaws that you see in real world cases, especially there in Chicago?
Absolutely. And that is what we'll call, as the defense attorneys, just investigating with blinders on, that a detective gets involved or a police officer gets involved and they have a conclusion in mind. They've been told who their suspect is, and it's a lot easier. It's a human condition. I may not like it, but I can wrap my mind around it, that if a victim comes in and says, well, John Doe did this to me, that following up with any of the evidence that points to John Doe is where the police go. Anything that may tend to prove that, no, maybe this wasn't John Doe, it was somebody else, or this didn't even take place, that isn't where the investigation goes. So that's probably the single most common thing, is that we'll call it blinders. It's having an end result in mind and focusing the entire investigation on that person and ignoring other potential evidence, or never even exploring to see if it exists or not.
So, speaking of blinders, how do you as a defense attorney identify when either investigators have put on blinders or the investigation was rushed or biased? Are there certain red flags that you always look for?
It's looking into what we'll get as a part of discovery. We will get the initial incident report or police report, and then we'll get what are called general progress reports, or GPRs. They'll be abbreviated. And oftentimes we will see if there are other witnesses who call in and if there are other potential names that are floated within an investigation. Oftentimes it's going to come from the outside. It's not that the police come up with another list of subjects or potential theories. It's, are there other witnesses? What do they say? Do they describe someone other than our client, or somebody doesn't match that description? And we squirrel that away. It's like, that's something we notice. It's like, well, there's a witness that says it sounds like our client, but then there are these other witnesses who describe a totally different individual, from what they're wearing to how tall, how much they weigh. Maybe they're even talking about somebody with a different nationality. It's like, we are totally talking about a different person. And that's something that we can note and say, well, it's interesting. One witness says something that's bad for us. It points in our direction. But then there are witnesses who say something else, and that becomes a topic of cross-examination, either at a preliminary hearing, or better yet, where it's going to carry more weight, is at a trial, and say, well, you had this other description of somebody else. What did you do to follow up with that? And the answer oftentimes is, well, nothing. We noted it, but there wasn't any further investigation because we went in this other direction. And it's like, okay, well, then you ignored other eyewitnesses, you ignored other evidence. In fact, you didn't go looking for other evidence. And that can be persuasive in front of a jury when we're arguing this was a rush to judgment, that this was an investigation with blinders on, that this was one where they had a conclusion in mind and they just ignored other evidence. That's where we can learn more about it, or just ask. Sometimes it's as simple as a victim says, again, John Doe did this to me. And you can ask that question. Well, where did you at any point try to test the theory that this individual may be lying? The answer more often than not is, well, no, we didn't really explore that theory. We didn't look for anything that would exonerate your client. We just followed through, brought charges because someone said you did it, or your client did it. And again, that is something that's probably more persuasive and stronger at a trial, because at that point, the state, and along with their witnesses, detectives and police officers, they're locked in. They can't then try to recreate a further investigation where they could say, oh yeah, we looked into person A, B, C, and D. No, you're tied into what it is you actually did, because now we're at trial. We're not in an early preliminary stage where they may realize, oh, defense could be onto something. Let's at least make it look like we tried to do something and make some phone calls and reach out to some other witnesses and just say it was not fruitful, because then they can say they actually did it, and our argument that they didn't goes away, loses steam.
I'd imagine, David, that these days, with everything caught on tape, it's potentially helpful to both sides. But can you talk about the role of things like body cam footage and surveillance video, or even missing digital evidence, in exposing investigative failures?
Absolutely. Video nowadays, it can, and you've hit on a couple of the main ones. In Chicago specifically, though I trust there are other jurisdictions, even in Illinois, but other states, there are video cameras everywhere, many of which are associated with the police. You've listed a few of them. Body cameras, those cameras that are actually worn by the police or detectives, individuals who are out on the beat or interacting with the public. That's one of the most common things that I expect to get now. There's an actual body worn camera act that officers are to be engaging their body cameras when they're on a stop. They're engaging with the public. They're questioning an individual. There are other types of cameras. We'll call them pod cameras, but these are cameras that are oftentimes managed by and then actually are maneuverable, where they can go in 360 degrees. They can move around so that if there's a report or a call, or they're just being surveilled by someone at the local police station, watching people, are people running around with guns? Is there a fight that breaks out and they can zoom in and zoom out? They can actually move the camera around. That's another one that oftentimes, if there's an allegation that something happened on the outside, it's like, well, is there any pod camera footage? Because that may very well exist. There are then other types of cameras, not traditional video in the sense that we may be thinking about right now, but there are license plate readers that oftentimes come into play, where there's an allegation that somebody fled to a vehicle, or maybe it was a hit and run, or a drive-by, or whatever it may be, and there's a basic description of that vehicle. Well, the police can go back and re-review from that area. Was there a red Honda around that time leaving the area, and then they can ping that vehicle from license plate reader to license plate reader, and then once they know the area and the time, get in body cameras and pod cameras and red light cameras. And then the big one that I think sinks an awful lot of cases is there's no body camera, there's no pod camera, there's no license plate reader, none of the above, but there are Ring doorbells or the equivalent, another brand, where there are cameras everywhere, and they're not necessarily obviously owned by the police, but as a part of an investigation, the police will routinely say, well, we know here's the body. It appears there was a shooting. There are no witnesses, but let's go door to door and see who has security cameras, who has a Ring doorbell, who has surveillance of their own home or a security camera in their own home. And maybe you'd be surprised, maybe you're not, how often they will catch at least parts of the incident or parts that can lead to the next step in their investigation of, well, we know the approximate time of the shooting. Here are the cars coming back and forth. Here are the people coming back and forth. These are the individuals we may want to question or try to investigate a little bit more closely. And one bit begets the other, but video is everywhere now. And that could be a big part of the state's case, of course, where they're saying, hey, we actually caught an incident on tape, or this is how we unpacked our investigation to find who it was that now stands before you today as the accused. When things don't exist, and they should, or we expect them to, in Illinois, we'll call that a Cladis motion. That's where the police should have retained video, be it of a statement at the police station, body-worn camera that should have existed that they didn't preserve or they didn't turn on, or whatever it may be. And depending on how the judge rules on such a motion, there can be a negative inference against the state saying, well, they didn't keep it because it hurts them, and so you should assume that this would have been bad for the state. Or the state is just foreclosed from using what they allege was on the tape or could have been on the tape, an admission that they actually saw a crime being committed and so forth, because we don't have the benefit of the defense side of getting to actually review it, analyze it, check its authenticity, question the person who recorded this video. There are some negative things that can be held against the state, but video nowadays in 2025, I almost expect there to be a great deal of it in every case we have.
Yeah, I mean, technology has really changed everything, as you know, in the courtroom and outside the courtroom. But let me ask you this. It's going back to that old school, do juries tend to trust police testimony by default? So let me start there. In your experience, are juries buying what police are saying?
It's an excellent question. And the honest answer is a very lawyer sounding question, is that it can depend. And it's like any other witness. And this is actually in the jury instructions now. So if we're at trial, we're before a jury, the instruction is that they are not to believe the police any more than they should the layperson off the street testifying. You're supposed to treat it the same way. Now, the concern is, from the defense specifically, is that you're going to have a man or woman who's in their dress blues, so to speak. They're actually police uniform and their shiny badge, and they usually present in a very professional manner because oftentimes they've testified a lot. They've been prepared by the state's attorney and so forth, that they are going to appear more professional and is as if you should believe them more than the average person. But the instruction says you're not supposed to. You should weigh their credibility, the weight of their testimony, in the same way you trust or weigh the testimony of anyone else. Now, while that is a concern, the reality is, over the last number of years, the trust in police has wavered. Rightly or wrongly is probably a great debate for another podcast and something we won't address today. But with the right set of individuals, with the right jury, a police witness could actually be a detriment to the state and a benefit to us, because people are looking at that testimony with a raised eyebrow, with a level of distrust that maybe 10 or 20 years ago, it would have been the inverse. It would be that fear that, well, if the witness, a police officer, says this, Well, what reason do they have to lie? They've been trained. They're just here to say what they saw and did, so that their credibility is almost baked into the fact that they're wearing a badge, and there was a higher connotation with the police, more positive connotation with the police. So now it can still waver. It's still a concern I have that we're going to go to trial, and if the main witnesses are police, unless we can objectively show that they're wrong because the video doesn't show it, or they're changing testimony from what's in a written statement, or there's just something objectively wrong that we can just show they're mistaken or lying, that there is a genuine concern here that that officer is going to, it's a psychology of human beings that they're more likely to perhaps believe them. But I think in modern days now, there is a bit more split there where that the state knows that there is a good subset of people that have distrust of the police, and that may be a detriment to the state. And again, a benefit to the defense, but it's a case by case situation. It can depend on the officer. It can depend on just how crazy their story is. And is it supported by any objective evidence, some sort of third party, something we're not relying on memory. We're not relying on opinion that can be verified or not. Every case is unique for that reason.
Yeah, and David, I mean, you've been doing this a while, so you know better than anybody. It's all about trying to impeach the witness on both sides, right? Question their credibility and also point out weaknesses in the investigation. That's part of your job. So let me ask you, can you share an example where pointing out weaknesses in the investigation either helped you win a case or really significantly shifted the direction of a case?
Sure. Well, there's two examples that come to mind as far as the investigation, and then one relating to video itself. One was, it was a sexual assault case, very, very serious. And there were some very serious allegations, of course, over what my client had allegedly done over the course of the better part of about a decade. And so the police and their detectives, and then later the state's attorney, after they chose to move forward with charges, that they were provided information or could have learned a great deal had they interviewed more people. And what I meant by that is that there were allegations that sexual abuse had happened in a home, and it was a home with a number of adults who had been in and out of family members. And so you follow up and say, well, okay, did they verify any of these allegations? Did they talk to anyone else in the home? Whether or not they had actually seen abuse, it was kind of immaterial. It was just to verify information. Who was in the home? Who wasn't in the home? When were they in the home? When were they not in the home? And so forth. And just come to find out, none of these people were interviewed. And there were things that within moments of sitting down to speak with them that I learned. So I outlined, well, okay, here's some of the allegations. One is that, because it stood out to me, an ironing table was used to block a door so that people couldn't come in. It's like, that's really weird. It's like, where do you guys do your laundry? Where do you do ironing? Because that just felt off. It was really unusual. It stood out to me. Well, immediately they just said, well, we don't even have an ironing board. What are you talking about? That's not something we've, okay, well, that is important. And it goes to one of the very specific allegations of the alleged victim, saying that this board was used to block a door. It's like, you don't even have one? Uh-oh. That's a problem for the state. And no one asked these questions. There was no follow-up, no attempt to verify bits of this story. So that's an example. We ultimately, the client was exonerated, was found not guilty. He's moved on, his record sealed and expunged, and the fact that he was even arrested. But that was an example among other things in that case that just showed, I'm going to call it a laziness, because there was just a hope and a belief that this victim was telling the truth. They took it at face value and really didn't do anything else to try to test the theory. Could they be lying? How believable is this story? Can we verify bits and pieces of these stories that were being told? And the answer was no, they did not. But I did, because I did speak to other people in the home. I did an investigation. And I think that carried an awful lot of weight, because not only did it kill the credibility of the victim or the alleged victim, it also went to show, like, well, if we can't believe this and we can't believe a lot of these other things, like, what do we have to go on? We just have the complaining witness's story that is bearing out to not be believable. Now, an example of a case where video proved to be absolutely vital. It was a gun possession case. And there were two officers who had pulled over a vehicle, had multiple people in the vehicle. And what we could hear and see on the body camera was that the lead officer was very focused on the driver, talking about what kind of movements he was making, and he was gesturing towards the center console and so forth. And it's all on camera. You can just hear it. You can see they're actually kind of pantomiming while the lead officer's talking to another about, did you see his, his right hand? He was kind of gesturing. He was moving over there. Yeah. Well, they go to search the car. They ask everybody out of the vehicle. They, of course, search that center console where allegedly there had been movement. There's nothing there. There's no drugs. There's no gun. There's nothing illegal. There's no contraband. There's nothing to move forward with a charge. They continue the investigation of the vehicle, the search of the car, and they find a gun near the back seat. There was kind of an entryway between the trunk and then the back seat where you could pull down one of the cushions, and they found a gun. Well, then magically everything turned to where my client was seated, because that's where he was in the back seat. He was the lone passenger in the back seat, and that's ultimately where the gun was found. Well, all he did was sit there. It's not his vehicle. He didn't make any gestures, no movements. Again, you could see it on tape. We get to trial feeling confident because of what's on where the guns recovered, and again, what we see on video camera. And the lead detective, or the lead officer, not a detective, but the lead officer, under direct examination, starts to say, well, yeah, we saw the back passenger making these gestures towards where we ultimately found the gun. And I'm furrowing my brow, jotting down notes, going like, are we talking about the same case? This isn't in the police report. This is just not, it's objectively not on video. Like, I'm confused, as to what this officer is testifying to. So cross-examination comes up, and I ask, it's like, well, you had body camera, correct? Yes. Okay. Was it working? Yeah. And it's been preserved? Yeah. You had an opportunity to review it? Yeah, it's been a while, but yeah, I had an opportunity to review it. Okay. Would you agree with me that these gestures you're talking about under direct, that you're actually talking about the driver, not the passenger? And he doubled down and said, no, I'm talking about the passenger. I'm talking about the passenger in the back seat. It's like, okay, roll that beautiful bean footage. And it's obvious at that point, he's talking about the driver. And even though he still wanted to double down and say it was the passenger, bring in the other officer. He's the next witness. Ask. Remember pantomiming gestures, and you were talking about potentially somebody hiding some contraband in the car? Yes. Okay. When you were doing this pantomime, or you were watching your partner do this pantomiming and talking about something, it was the driver, right? Right. Exactly. And, within moments, it was a bench trial. The judge comes back and says, it's not his car. There's no proof of any knowledge. The officers believed it was somebody else. I didn't see the passenger do anything. Not guilty. Why? And I think we could have potentially won without the video, but what sunk it, what made it an immediate verdict where the judge really didn't even have to collect his thoughts or notes, was because the credibility went away. The video was very clear that they were talking about someone else. The video was very clear that my client hadn't done anything. So it was a mixture of the credibility of these officers being shot, and then the video showing my client didn't actually do anything. We won that case. Could we have won it without it? Probably, under the law, but there had been a lot more questions, and there had been no way of crossing the officer about who he was talking about and doing these gestures and so forth. So thank God for body camera. It came through for the defense in that case.
Great examples, David, all the way around. We really appreciate your time and your expertise. And thank you all for joining us on Defending the Windy City with David Drwencke. Visit drdlawllc.com to connect with David and his team. And don't forget to like, subscribe, and leave us a review. Thanks for watching.